In the high-stakes theater of American litigation, Donald Trump has long utilized the courtroom as both a shield and a megaphone. However, his latest legal gambit against the Wall Street Journal suggests he may have finally stumbled into a trap of his own making, one that threatens to exhume the very secrets he has fought so desperately to bury. By doubling down on a defamation claim regarding his past ties to Jeffrey Epstein, the president is inadvertently opening a door to a discovery process that could prove politically and legally catastrophic. The catalyst for this legal quagmire is a report published by the Wall Street Journal concerning a birthday card Trump allegedly sent to Epstein for the financier's 50th birthday. The note, which reportedly alluded to the two men sharing secrets and the enigmatic nature of aging, was met with a characteristic firestorm of denials from the Trump camp. Trump dismissed the letter as a total fabrication, going so far as to suggest, albeit hyperbolically, that a time traveler must have planted a fake document within the Epstein files to frame him. This reflexive denial led to a defamation lawsuit, which has now reached a critical inflection point in federal court. Initially, a federal judge dismissed Trump's complaint, ruling that the legal filing failed to meet the high threshold for actual malice. In defamation law, particularly for public figures, it is not enough to allege that a report is false. The plaintiff must prove the publisher acted with reckless disregard for the truth. While the judge threw out the initial case, he granted Trump leave to amend, a common judicial courtesy that allows a plaintiff to fix technical flaws and refile. While most litigants might take a dismissal as a sign to retreat, Trump has indicated he intends to push forward, a move that legal experts suggest is less a strategy and more of a self-imposed snare. The danger for Trump lies in the transition from a motion to dismiss to the discovery phase. Typically, Trump's legal playbook involves gaming the system, stalling, seeking extensions, and dragging out proceedings for 12 to 18 months until the public's attention drifts elsewhere. This drag-it-out strategy has served him well in international affairs and various civil suits, where the goal is to let the controversy fade into the background of a crowded news cycle. However, by refiling the specific case, he becomes a plaintiff, a position that strips him of many of his usual delay tactics. If the case proceeds, the Wall Street Journal gains the most potent weapon in civil litigation, the deposition. As the person bringing the suit, Trump would be legally obligated to sit for hours of recorded testimony. Unlike his previous depositions with New York Attorney General Letitia James or the E. Jean Carroll legal team, which were already described as disastrous, this deposition would be laser-focused on his relationship with Jeffrey Epstein. Defense attorneys would have a right to grill him for 7 hours or more on every statement, flight log, and social interaction tied to the disgraced financier, arguing that such questions are reasonably calculated to lead to the discovery of admissible evidence.